Good afternoon. Thank you for attending our first webinar of a three-part complimentary webinar series discussing California's new affordable housing laws. We hope you enjoyed today's presentation and mark your calendars to attend the next webinars on January 23rd and February 8th. A few things to get us started for today's webinar. All of your telephone lines are muted. On the top of your screen, there is a Q&A button. During the webinar, if you would like to ask the presenters a question, please submit your questions using the Q&A function. John and Ava will do their best to answer all questions during or at the conclusion of the webinar. We have quite a few attendees registered today, so if your question isn't answered, we will follow up with you after the webinar via email. We are offering CLE credit for this webinar. CLE certificates and a copy of the PowerPoint will be emailed to all attendees next week. And now for our webinar. Governor Brown signed 15 bills into law on September 29, 2017 that are designed to help address California's affordable housing crisis. The approved bills take different approaches to the housing shortage in California, including providing more funding for affordable housing development, streamlining local government approval of housing projects, restoring local government's authority to impose inclusionary housing requirements on private housing developers, and strengthening the state's anti-NIMBY laws. The new laws have broad implications and obligations for local municipalities, housing-related public agencies, and the private developer community. To help explain the new affordable housing regulatory landscape, we will begin our series with today's topic on new methods to create affordable housing, presented by John Getz and Ava Plaza. John Getz is a principal at Meyers Nave. He has 30 years of experience in real estate, land use, environmental, redevelopment, affordable housing, and municipal law. John represents a broad spectrum of private sector landowners and real estate developers, cities, housing authorities, universities, and other public entities in complex real estate transactions, land use planning, public-private development, infrastructure financing, and affordable housing transactions. He also has advised on more than 150 housing developments and programs involving thousands of affordable and market-rate housing units. His housing projects include a variety of housing types, including affordable rental development, mixed income for sale housing communities, master plan communities, and mixed-use and transit-oriented developments. Eva Plaza is of counsel in Meyers Nave's Trial and Litigation Practice Group and Municipal and Special District Law Practice Group. She represents private businesses and public entities in a wide range of litigation, transactions, and regulatory matters. Ava has served as lead counsel in all aspects of municipal law with particular emphasis on land use, contracts, redevelopment, and economic development, including affordable housing and construction litigation. She has represented cities and redevelopment housing agencies in connection with the Assembly of Land for reuse and redevelopment to support commercial, industrial, or residential development. She has served as city attorney for California cities, chief city attorney for a major city in Pennsylvania, and was appointed by President Bill Clinton to a Senate-confirmed position as Assistant Secretary at the U.S. Department of Housing and Urban Development in Washington, D.C. John, Ava, thank you for being here with us today.
Thanks,
you.
Stephanie. So, this is John Getz, and I think we have an interesting program for you today. I'm a veteran of the redevelopment program over the years and the demise of that program, and we've been focusing on affordable housing for many years. And 2017 was an extraordinary year in that virtually all the policy ideas that have been floating around for years on affordable housing all got enacted in the same year. Many of you might have seen the dramatic signing ceremony that Governor Brown held signing the 15 bills in the package. There are actually more bills beyond that were passed by the legislature affecting affordable housing that year as well. And here at Meyers Nave, we've been working on getting through those bills and making sure we understand what kind of tools are now available in the housing and affordable housing areas. So today, we are going to focus on 4 of those legislative bills, and we'll also be touching on some of the local government approaches. And what they have in common is that all the bills and local government approaches are aimed at increasing the supply of affordable housing within the state or the jurisdiction. So the first bill we're going to talk about is Senate Bill 2. The author was Senator Atkins of San Diego. This is titled the Building Homes and Jobs Act. We've been calling it the Permanent Source Bill because that's been the term that the proponents have used over the years for this. This permanent source has been a goal of the affordable housing industry for many years, led by the California Housing Consortium and Housing California. The idea was to come up with an ongoing source of funds that would be available for affordable housing that's not dependent on voter approval, like bond issues, or not dependent on the state budget process, which many of us have come to realize over the years is not a dependable source of funds. So the idea became more critical after the demise of redevelopment in 2011 and 2012, since the redevelopment generated about $1 billion a year for in low and moderate income housing funds for affordable housing programs. When that went away, we lost a critical source. During the recession, federal funds also had declined for affordable housing, so the need for this became fairly severe. So what Senate Bill 2 does is it enacts a new fee on recorded documents, and that fee went into effect on January 1 of this year, $75 a document, maximum $225 for a transaction. And these are on recorded real estate documents, things like grant deeds and deeds of trust and easements. There's a whole long list. Importantly, though, the home sale documents are exempt. And that probably arose from the fact that the strongest opposition to this idea from the beginning was the California Association of Realtors, who did not want a fee or tax on their transactions. By this exemption, the realtors actually became a supporter of the bill. There was a long process in determining what an appropriate source would be for this, and this source, the recording fee, was considered to be the most politically doable and fair type of fee. The initial estimates are $200 to $300 million per year in fees generated. We'll have to see how this actually works as time goes on. That's not as much as we lost with the redevelopment, low and moderate income housing funds, but it's a very hefty amount that will continue over time. Now, it's important to know that the funds are going to be distributed in different ways in 2018 and then in future years. In 2018, the funds are going to be distributed 50% to cities and counties and 50% to the state for homeless assistance programs and other projects. The funds that are to be distributed to local governments are to be used just to update planning documents and zoning ordinances, planning uses. The common aspect of this is that the planning processes have to be used to streamline housing production within the jurisdiction. Now, this is not an entitlement program at this point in 2018. Cities and counties must request the funds. We don't know exactly how you do that yet, and how competitive the program will be, but that's something that we'll be keeping an eye on as the information comes out. We think that cities and counties should be thinking now about how they might want to use these funds and what types of planning processes might be appropriate in your jurisdictions, and it may be time to start lining up the consultants that could do the work as well, because there may be a drain on those people that are able to do this work. Now, this is the only portion of the SB2 funds that will be specifically available for planning activities. So the advice, I think, is to start focusing on what those top planning priorities are. Now, in 2019 and beyond, the allocation system and the uses of the funds completely changes. At that point, 70% of the funds generated in 2019 and beyond will go to cities and counties. And the bill has written into it a funding formula that's an entitlement formula, and they're using the same method that's used to distribute community development block grant funds from the federal government. There's also a competitive grant program available for 10% of those funds for non-entitlement jurisdictions to get their hands on those funds. Excuse me, those funds as well. The other 30% will go to the state for some specified programs. Now, there are some requirements for receipt of the funds. You need to submit a plan for the use of the funds with priority for 60% of median income below. You need to be in compliance with the housing element. You need to submit an annual housing element report, which is a new requirement that goes into effect this year. And there's a need for fund tracking to Housing Community Development Department. But in general, understand that this is an entitlement program. These funds go to the cities and counties based on this formula, and it's not a competitive grant program. So the funds will come in as long as you meet those requirements. Funds will revert to state housing department if they are unallocated after 5 years. They don't have to be spent in 5 years, but there at least has to be a plan for how those funds will be spent. Some local agencies may not be interested in the funds, and they are able to give the funds back to the state. The great thing about this program, at least now, is that it does allow quite a lot of local discretion, although I predict there will be more legislative direction added over time. The funds can be used for programs serving people up to 120% of median income, and that's important because there really aren't that many funding programs that are available for people of that income group, and that even goes up to 150% of median income in high-cost areas. It can be used for a whole variety of things: development of affordable housing, acquisition, rehab, preservation. We think it'll be a great source of funding for projects that get low-income housing tax credits. Affordable ownership housing is specifically called out, and as we've known through the years of redevelopment, down payment and mortgage assistance programs are very popular. I'm sure some cities and counties will want to use the money for that, also for acquisition of land for those types of programs. Homeless programs and projects is also a allowable use, and we think that some cities and counties may join together to combine those funds from regional and multi-agency approaches. Again, it's still a long list of what those funds can be used for: matching funds for local and regional housing trust funds, capitalized reserves for services for supportive housing projects, accessibility modifications, acquisition rehab of foreclosed or vacant homes. One interesting idea is that funds can be used for fiscal incentives to local agencies for approval of low-mod housing. It'd be interesting to see how this might actually be used. And again, funds can be used jointly by more than one local agency, And importantly, for the cities and counties, 5% of the funds can be used for administrative costs, which is always important in these programs. So that was an overview of that program, which should be rolling out shortly. Now I'm going to turn over discussion to Eva, who'll talk about the SB3 and the statewide bond measure.
Thank you, John. Good afternoon. So I'm going to talk about SB3, Senate Bill 3, the statewide housing bond measure, also known as the Veterans and Affordable Housing Bond Act of 2018, which will be on the ballot as a ballot measure in November 6th of 2018. One thing to keep in mind about this is that it will be effective immediately upon approval, so that because it's considered an urgency statute. However, what that means is there's obviously going to be some planning on the part of cities and agencies before the money is turned around to various sources. So $3 million of the bonds will be backed by the full faith and credit of the state, and bondholders will be paid their principal and interest. And it's targeting infill infrastructure financing, affordable housing matching grants, veterans, and farm workers. I'm not sure if you're aware of this, but California has approximately 21 to 24% of the nation's homeless. That's 1/5 of the nation's homeless, if you can believe that. Also, in California, it takes an hourly wage of $26.65 to be able to afford housing in California. So that's the reason this bond measure is considered urgent. So the $1.5 billion would be placed in something called the Housing Rehabilitation Loan Fund. And part of it will be used for multifamily housing, for new construction, rehabilitation, and preservation of housing. Some of it will be used for permanent and transitional rental housing, and some of it will be used for low-income people defined as making less than 60% of the median income, and also for technical assistance, such as CEQA, maybe some planning in there. Now, this is all because, again, of the extreme housing shortage in California. There's, I believe, 2.2 million low-income families who compete for approximately 664,000 affordable rental homes. So that leaves about 1.54 million families or people without affordable homes. So the next chunk of money from this trust fund, the Housing Rehabilitation Loan Fund, is going to go to TransitOriented Development Implementation Fund. And it's going to be approximately $150 million, or actually $150 million. And that $150 million will be used for high-density uses. And so multifamily high density within close proximity next to transit stations. And the money will be set aside for loans, grants, for state incentive programs, and such. There will be $300 million that will be set aside for farm worker housing. So that's called the Farmworker Housing Grant Fund, and that will also include infill incentive grant programs and high-density affordable and mixed-income housing. And so this farm worker housing portion is to address the displacement of farm worker families and for housing for agricultural employees and families, for the construction and rehabilitation of housing, and that would include grants, loans to nonprofits, to local public agencies, to LLCs, and also would include technical support. So this chunk of money is for acquisition, also for acquisition of manufactured housing. Interestingly, it also includes parks, so for the creation, rehabilitation, and development of parks. The next big chunk of money is going to go to the Housing Innovation Fund Grant Program. And these are competitive grants or loans that are made to housing trusts, to local housing trusts, and they are made to develop, own, lend, or invest in affordable housing. And these housing trusts are, as you probably know, are these trusts that are financed with both private contributions or unrestricted government funding. And the next major chunk of money, $300 million, will be for SelfHelp Housing Fund, or the Cal Home Program that I'm sure you're familiar with. And this money will be for direct forgivable loans for multiple homeownership units, such as, condos or apartment buildings. It will be used for mortgage assistance and manufactured homes. And of the $300 million, $30 million will be for mobile homes and technical assistance. And the state may also provide technical assistance or facilitate construction of housing up to $360,000 of this $300 million. But no entity may receive more than $30,000. Now, for this money, the preference will be given to public works or to construction with per diem wages. And now I'll turn it over to John for a discussion of 1505.
Yeah. And actually, before we go to the next bill, a question for Eva, and that is, the statewide bond measure is on the November ballot later this year, and it might be good to refresh everybody on the rules of what type of things cities and counties can do with respect to statewide bond measures in terms of supporting or I know there are restrictions on that.
Yes, and for that I would urge everybody on the phone to consult with their lawyer, because there are restrictions on advocacy on the part of cities and counties and public agencies, and that doesn't mean that individual members can't support a bill, but as cities and counties, I would caution everybody to look to their city attorney.
That's a good idea. So now let's talk about the next bill in the package, and that's Assembly Bill 1505. Author was Assemblymember Bloom from West Los Angeles County area. And this bill relates to inclusionary housing. And, this is a bill that I think in most years would have been maybe the biggest news that of the year in affordable housing legislation. In 2017, I think it kind of took a back seat to some of the other bills, but it's really a very significant bill and an idea that also has been floating around for a number of years. And just as a little background, although it's not required by state law, there are quite a few cities and counties that have adopted inclusionary housing ordinances. The estimate is that we see is 170, although it could be much higher or lower than that. And inclusionary housing ordinances generally requires a specified percentage of new housing to be affordable to low and moderate income tenants and owners, and often specify that by different income brackets. And those ordinances generally also include alternatives to providing on-site affordable housing. Many of these ordinances have the possibility of an in lieu fee, a fee that would be paid by the developer instead of providing the affordable housing. And there's also options to do affordable housing in different ways, such as off-site construction and donation of land to either the public agency or perhaps to a nonprofit. So while a number of cities and counties have inclusionary housing ordinances, in 2009, they were really thrown for a loop by a case that came down that year. It's known as the Palmer 6th Street Properties LP versus City of Los Angeles, or just often called the Palmer case. And in that case, the City of Los Angeles had required that an apartment developer provide affordable housing, not through an inclusionary housing ordinance per se, but through a specific plan, but a very similar type of provision. And the developer sued the city and was successful in the court saying that cities would not require affordable rents in apartment projects under the Costa-Hawkins Rental Housing Act, which is the state law that restricts local rent control. And that Costa-Hawkins Act, when it was adopted by the state legislature, it was really not understood as a restriction on inclusionary housing, but it does have language in it that prevents cities and counties from telling apartment owners what rent they can charge for their apartment units, particularly for the initial occupant or the initial user of the apartment. Now, when this case came down, some cities and counties responded by modifying their ordinances to exclude rental housing. Some just left their ordinances as is, but didn't enforce it against rental housing. Some switched to kind of a hybrid approach and emphasized the use of the density bonus and financial assistance being provided to the housing developers, which were exceptions under the Costa-Hawkins Act. But so there was a variety of approaches taken. So in the meantime, we got a ruling from the California Supreme Court, which looked at a different type of challenge to inclusionary housing from the Building Industry Association in a case involving the City of San Jose's inclusionary housing ordinance. And the Building Industry Association has long felt that these inclusionary housing ordinances needed to be analyzed under a very restrictive takings analysis, and would look at what the nexus is, the relationship between the impact of the development and the supply of affordable housing in the city. And it's a standard that would have made it very difficult to have successful inclusionary housing ordinances in the state. The court, however, said, no, that's not the way this needs to be analyzed. Instead, they said, we'll review ordinances under a much more deferential standard the same standard that's used for other land use ordinances controls of cities and counties, and that's whether the regulation is reasonably related to the public welfare. And that's a standard that is very permissive and allows really the common practices of inclusionary housing. The court also made strong findings that there is a strong need within the state for legislation relating to affordable housing. So this built a very good basis for inclusionary housing. Now, 2017 with AB 1505, the bill, a very simple bill actually, and it basically just allows cities and counties to adopt inclusionary housing requirements that regulate rental housing. And there's a specific statement of legislative intent there that the intent was to supersede the Palmer case and say that doesn't apply. It does require some alternatives be built into the ordinance, but those tend to be the types of alternatives that most of the cities and counties have already put into their ordinance, so that shouldn't really have too much effect. Importantly, it does not set a limit on required affordable housing percentages, but it does, late changes to the bill did add a requirement for cities and counties that want to require more than 15% low-income units, and that would include low or very low-income units. The state housing department may ask for to review the ordinance and to for the jurisdiction to provide an economic feasibility study to show that the ordinance does not unduly constrain the production of housing. And here I think the concern was that that perhaps some cities were using inclusionary housing requirements not really to generate affordable housing as much as to chill the development of new market rate housing. So that's really what that is about. My guess is that there are not that many cities that have gone beyond 15% low and very low income units at this point. It's important to know also this applies to only new requirements that are adopted after September 15th of last year, and so this requirement would not apply to existing ordinances that have these standards. So what are some practical tips? What if you're a city or county, what should you be doing at this point? Well, if you have an existing inclusionary housing ordinance, this is a good time to check to see if that existing ordinance does cover rental housing. Some ordinances are not as clear on this point as others, so that's the first thing you want to look at. Second, make sure that the ordinance does have the required alternatives to on-site affordable housing. It doesn't have to have all of the suggested alternatives, but it has to have some to be valid. If the jurisdiction is considering requiring more than 15% low-income units, then you may want to do the economic feasibility study at the outset and make sure that you've got a good factual basis for doing that it's not going to kill your housing market. It is a good idea, we think, to take a look at the San Jose ordinance that was approved by the Supreme Court. This is one of those good opportunities where you actually have an ordinance that you can see has been court approved, and you may want to look to see kind of what is in that ordinance and what are the things that the court thought was important. And important also to remember that even though we now have AB 1505 that authorizes inclusionary housing for rental housing, we have the San Jose case that provides good support for inclusionary housing in general. It doesn't mean that these ordinances are completely out of the clear. Taking challenges remain, particularly for those ordinances that are seen as excessive and might have impacts on the market that prevent housing from being built. So,
Hi, John. I have a question. Now, I know that we will be working, and we've already started working with some of our clients to update their ordinances. Is that correct?
we're starting to get questions now. That's right.
Okay.
And I would just say that we're looking at these now, and make sure that I would say make sure that your legal team is involved. There's a lot of complicated questions in these things, so it involves both a blend of policy concerns and legal matters as well. Mm-hmm. So, I want to just talk briefly about one of the bills that has not gotten a lot of attention at all, and that is it's Assembly Bill 1598. It adopts a new type of governmental entity that's called an Affordable Housing Authority. The intent is that these types of authorities will be able to collect property tax increment that could be used to help subsidize and assist affordable housing. The structure of these is very similar to the enhanced infrastructure financing districts and community revitalization authorities that were adopted in the last few years post redevelopment. It's an idea where the city, the county, and special districts can each voluntarily contribute some or all of their property tax increment from a district into a pot of money that could be used for a purpose. This particular bill would direct the money specifically to affordable housing for both low and moderate income, as well as workforce housing for incomes above what's normally considered moderate income housing. This is not free money. This is cities, counties, special districts agreeing to put their money into these pots. It can be difficult to get that agreement from those jurisdictions, but for those jurisdictions that do have a strong commitment and want to commit some of their dollars to affordable housing, this might be an interesting idea. For those who are looking at this, they ought to also look at the other infrastructure financing opportunities available, particularly the EIFDs, and compare and contrast to see which would be the best structure for what they're trying to accomplish. There are pros and cons of each approach. So now we're going to turn from the state legislation to things that the local governments have been doing to also provide additional resources for affordable housing. We're going to talk about a couple different approaches, although there are many out there. But first, Eva's going to talk about the approach taken by City and County of San Francisco, as well as some of the other Bay Area communities. Thank you, John.
There are 9 counties in the Bay Area, some of them doing very interesting things. In San Francisco in particular, you have the San Francisco Affordable Housing General Obligation Bond, which passed in November of 2015 with a 74% approval by San Francisco voters. And the goal is to construct 30,000 new or rehabbed homes, half of which will be for low and moderate income San Franciscans. It's being distributed $80 million for public housing, $100 million for low-income housing, which is defined as 80% of median income, $50 million for designated mission area, plan investment, and $50 million for middle-income housing. What I would say about this is it's unique in that, for example, there's in the construction and acquisition of existing apartment buildings, there's city loans that will be made available to developers so to jumpstart development. And these developers then go out and hire contractors to work on the projects and thereby create jobs. And they also, these developers will set themselves up via LLCs, and they will, in some cases, own the actual improvements to the land while the city or county owns the actual land through affordability covenants for 99 years. So that's a very creative way to enhance and encourage developers to build and to build, construct, and acquire certain existing apartment buildings. There's also going to be some low loans for first-time homebuyers, where these loans might be forgivable or they might be due after a certain period of time. And liens are attached to the title, so they don't actually own outright the property. And then it could be repaid at a time of sale through the appreciation value in the property. So San Francisco has come up with some really, really creative ways to do affordable housing, including identifying certain existing buildings and identifying something called small sites through a program called Small Sites Program. And these are, existing buildings that have less than 25 units. And the goal is to remove those smaller sites or buildings from the speculative market and to thereby protect and stabilize housing for the current tenants, where multiple generations have lived in that apartment for a long time. So that's really what I would say about the San Francisco Affordable Housing General Obligation Bond of 2015. But I would urge all of you to take a close look at the other Bay Area counties and to see what it is they're doing. For instance, in the case of San Mateo County, they didn't want to do bond money. They didn't want to tax their residents anymore with bond money. So what they did is they extended an existing measure known as Measure K, which had a sales tax, which was a sales tax measure that provides money for affordable housing. So they extended that instead of doing a bond. And as some of you may know, Walnut Creek has done quite a bit of affordable housing over the years. So take a look at these examples of what other cities have done, because I find that they are very creative. Thank you, John.
So now I want to talk about another example of something happening in Southern California, and that's the city of Los Angeles, which just adopted a linkage fee last month, December. And the linkage fee differs from the inclusionary zoning approach that have taken by many other cities and counties. but the linkage fee spreads the costs over both commercial and residential development, unlike the inclusionary housing, which is just imposed on residential development. And this produces a larger, more diversified stream of funding by doing that. So the Los Angeles approach is one that's been taken by several other larger cities in the state that also have linkage fees, like San Francisco and Oakland and San Diego. So the linkage fee was adopted. It's going to be used to fund creation of affordable housing within the city. The ordinance has a tiered fee schedule with, it doesn't have uniform rates, but it has rates for housing projects that range from $8 a foot in what it calls the low market areas of the city, which is places like South Los Angeles and the San Fernando Valley, up to $15 a foot in what it calls the high market areas, which is the more affluent areas of the city, like the West Side. There's smaller attached projects with 5 or fewer units, have lower fees, $3 to $5 a foot. Actually, that's $1 a foot. And then commercial projects are charged at $3 to $5 a foot, also depending on where it is within the city. There are some exemptions from the fee as well. Now, the city also decided to have a tiered approach to, or a rollout approach to the fee, where fees that are, or projects that are currently in the pipeline are not going to be charged the fee, and then they're going to start charging the fee at 1/3 of the total amount for about a 6-month period, and then for another 6-month period they'll be at 2/3, and then eventually we'll charge the full amount of the fee. It's expected to generate $100 million annually, and virtually all cities and counties would love to have that amount of money to play with, and it's going to be available for a full range of projects. So again, another different type of approach, a city taking the initiative on this. So we've now finished our discussion of the bills and the local government approaches, and if you have any questions, we'd be happy to answer those. First, I see there's a question from one of the listeners about the multifamily housing program and what the dollar amount of that program is. And Eva, I don't know if you can help with that.
We have, yes, we have for multifamily housing. There's the Housing Rehabilitation Loan Fund, and for that, it's $1.5 billion. Now, that's going to be divided into various chunks, but it's for construction, rehabilitation, preservation, etc. But it's $1.5 billion.
Okay, great. We got some questions about the inclusionary housing bill as well, and I'll try to answer some of those. One of those is, if a city had an inclusionary ordinance prior to the Palmer decision and never repealed it, is there a need now to adopt a new ordinance or reaffirm the old ordinance in reliance on the new legislation? And I think the bill itself does not really answer that question. So I think that the legislation would allow you to go either way. One thing you might want to look at is whether the city or county's ordinance that was originally adopted, has it been enforced over the years or not? Is there any need that you see to make any changes to reaffirm that what the rules are? There could be issues if an ordinance was adopted years ago and just hasn't been enforced, would developers challenge the enforcement of that requirement now after it's been non-enforced for all those years? Another question is a city, instead of having the inclusionary housing for rental housing, the city adopted an affordable housing impact fee. Can the city have both the impact fee and the inclusionary housing, and is one approach better than the other? So can a city have both? I mean, most cities would go with one or the other. Certainly it has to be looked at as a cumulative effect. If you had an impact fee and a requirement for affordable homes, could easily get to a level that becomes excessive and might be seen as a regulatory taking. I will say, though, that there is a fairly significant difference in the enforceability of a fee versus the enforceability of the inclusionary requirement that requires the construction of affordable units. And that goes back to that San Jose case. The impact fee is subject to all the nexus requirements, the AB 1600 Mitigation Fee Act of the state, requirements. You know, there's quite a few requirements that go along with that, and quite a few ways for developers to challenge those fees, where the Supreme Court said that for a requirement for affordable houses to be built, the straight inclusionary requirement, they will use the more deferential standard of whether there's a reasonable relationship between the need and the requirements imposed. So I would say between the two, the inclusionary requirement is the more defensible, and again, most cities and counties have adopted the in lieu fee as the alternative to creating affordable housing, and that's generally the easier way to impose that kind of fee. Do we have any other questions? So I think I think we pretty much were able to cover our material here. We all thank you very much for taking time during your lunch hour today to listen. This has been for us involved in the affordable housing world. It's been a very interesting time trying to sift through the new legislation and figure out how it applies in the real world. I know all of you will be doing the same thing, figure out how it applies within your companies or your cities, counties. We hope that you'll join us in the future webinars. We'll be going through the additional bills in the package. This is different approaches, and now I guess we're looking at January 23rd and February 8th for those future webinars. I think you'll be getting information on that. And again, I thank you.
Thank you very much for joining us today.
Thank you all. You will receive a copy of the PowerPoint and MPLE certificates early next week. Have a great day.